getting into planning for your child, and this is going to, some of this is going to be referring back to power of attorney stuff. But with your child, when your child is an infant, there has to be a guardian of your child. Now, infant is a statutory term in BC, and there's an Infants Act. And I remember talking to a client and talking about how we needed a, you know, I used the term infant. Oh, but he's 16. Well, he's still an infant until reaching the age of majority. So that's why teenagers act the way they do. It's statutory.
It's the legislation.
The BC government decrees it. So your child ceases to be an infant at age 19. Now, while the child is an infant, you're the guardian of the person of your child. So in the legal theory, you can determine when the child has to be home. That sort of breaks down at a certain age. But now, you're not the sole guardian of the property of your child when your child is an infant. So you share that authority with the public trustee of British Columbia. That's a government agency, and they take care of people who have nobody else to take care of themselves. But they also have shared jurisdiction over the property of your child because they're a representative of the Crown, the Queen, and the Queen, in traditional English jurisprudence, the Queen was, or the King was, always took care of his or her subjects, and it was a royal prerogative to take care of children. So that's why we have the office of the public trustee. Now, they tend to be overworked, but they're very good people, but they're underfunded and overworked. If your child is an internet sensation and has a lot of money, unless you structure things properly, and we'll get into trust later on, you have to deal with the public trustee as to how you deal with that money. Now, this is a principle of law that is largely ignored in our society because, strictly speaking, when your child goes to buy the latest iPod, the store should say, well, you're under 19, I can't deal with you. But of course, the store will take the child's money and sell them an iPod. So it's one of these situations where the law is largely ignored in day-to-day practice, but if you had a significant amount of money, then you would run into this problem. But
if your child had a significant amount of money.
If your child has a significant amount of money, then you have run into this problem of how do we deal with it. And that's why people don't give significant amounts directly to a minor child, under 19, because the child legally can't deal with the money without involving the public trustee. And there's the other thing that it's probably a mistake. It would have been a mistake for my parents to give me a lot of money at age 19. So, guardianship, coming of age.
So on your 19th birthday, you become an adult. And this means that the parent can no longer act for the child, which actually has really important ramifications. Because for many of us, turning 19, great, we're an adult, we can deal with our own thing. But for some people who maybe have a little bit less capacity to deal with things, when they turn 19, their parent can't act for them anymore. So it's really important. We call it a coming of age ceremony, and we're law nerds, so we think it's funny. But anyways, at age 19, it's a good idea to have your child sign a power of attorney and a healthcare representation agreement, because as a parent, you can no longer do those things for them. So you can't deal with a bank account that they may have. You can't deal with an RDSP that maybe is in their name.
The child's doctor will not give you any information unless you have a healthcare representation agreement saying that you are able to get information from that doctor. Because the doctor will say, oh, your child's an adult, I can't disclose anything.
Yeah. So that birthday is actually quite significant, I think, if you have a child with a disability. It's a really important one to keep in mind. You can't just keep doing things that you could before.
It's an important coming of age ceremony. Now, in a lot of primitive societies, they take their child at the coming of age ceremony, and they, the child goes out into this forest in the dead of night, and they have to sit there, and they have to deal with wild animals and lots of dangerous things. But we're much more civilized. In our coming of age ceremony, we take the child down to see a lawyer. Yeah, maybe that's not so good. The sole exception, and this is a recent change, on 16th birthday, a child can now do a will. It used to be 19, now it's 16, and that's because of the registered disability savings plans, which we'll get into a little later. Any money in an RDSP belongs to the child ultimately. So if the child died, the money in the RDSP would go as part of the child's estate. So when your child turns 16, if your child has an RDSP and has the capacity to make a will, it's a good thing to have the child sign a will, just so there are some rules in place for dealing with that RDSP money.